Okay, welcome everyone to HIALSA's first workshop panel of this spring semester, and also the fourth one in the academic year on oral advocacy in international arbitration. So today we have again the honor of having a wonderful and also very diverse panel, both in terms of experiences and geography. And we're also lucky to have Ms. Paige von Maren from Freshfields, New York. She is also actually an alum of Harvard Law School, and in fact, she was actually a former president of HIALSA. So we would like to thank you, and very excited to welcome you back in Cambridge. So as a reminder, please fill out the attendance sheet that is being circulated for purpose of the end of year certificate for the workshop. And we'll also videotape this session, so the link will be on HIALSA website. If you have class at 1 p.m., we would like to ask you to leave quietly without interrupting the panelists. So I'll leave the floor to Paige. Thank you.
Hi, everyone. Oh, okay, can you hear me? Excellent. So thank you very much to HIALSA for inviting me and inviting us to come speak to you today about oral advocacy and international arbitration. And thank you to all of you for coming out. I want to take just a few minutes to introduce our distinguished panel, so I'll just go down the line. Immediately to my left is Claudia Solomon. Claudia is a partner at Latham & Watkins, based in New York. She is the global co-chair of Latham's international arbitration practice. She's also a vice president of the ICC Court of Arbitration and has a very active practice in front of all of the major institutions as an arbitrator and in arbitration-related litigation. Next is Andres Romero del Maestro. He is a supervising counsel with Chevron's Enterprise Litigation Group. Over his, I think, 21 years with Chevron, maybe more. More now. Andres has handled disputes all over the world and lived all over the world, for that matter. His practice focuses on complex, high-stakes, cross-border, and transnational disputes. Next, we have Igonikon Adekunle. She is a partner at Templars based in Lagos. She is a member of the Lagos Chamber of Commerce International Arbitration Center. She routinely acts as counsel in both institutional and ad hoc international arbitrations, and also represents clients in large commercial disputes in Nigerian courts, including disputes with the Nigerian government and its agencies and instrumentalities. Next, to Igonikon's left, we have Ziad Obeid, who is a partner at the Obeid law firm in Beirut. He has a civil engineering background, which allows him to bring a unique and valuable perspective to his clients' disputes. He regularly acts as counsel in complex disputes, both commercial and investor state, as well as sitting as arbitrator, and also represents clients in high-stakes cases in Lebanese courts. And last but not least, down at the end, we have Liz Snodgrass, who is a partner with Three Crowns based in Washington, D.C. Liz has acted in more than 40 international arbitration matters and has an incredibly active practice that takes her all over the world for both investor state and commercial arbitration. And she has particular experience, and having worked with her on one of these, I think I can say skill, in handling disputes with states and state-owned entities. So with that, talking about how we actually get there, because even though some of the best oral advocates make it look effortless, there's actually, as I think everyone here can guess, quite a bit of preparation that goes into that process and goes into that sort of effortless or seemingly effortless presentation. So to tell us a little bit about how they prepare for oral advocacy, Igonikon and Liz, whoever would like to start us off first.
Thank you, Paige. Well, preparing for oral advocacy, I think the first thing I would say is that practice makes perfect. You must practice. You can read everything and listen to everything that's been said, but for me, personally, you must be part of a team. You must practice a lot in terms of what you see, how you learn, what you assimilate from other counsel or arbitrators that are good at what they do. And there are a lot of things you learn by being part of a team, by watching how it's done. And evolving your style. And another critical thing to remember is time. You don't have a lot of time, unlike when you're filing the written submissions. There's quite a lot of time. You have months, even close to half a year sometimes in filing testimonials, memorials. But when it comes to oral advocacy, you have time limits. So you need to make sure that you're prepared in convincing, because for me, oral advocacy is the art of persuasion. You want to persuade the tribunal to find the issues in your favor. So simply talking, all these things we've been saying is make sure you are able to lead the arbitrator to come to a conclusion that is favorable to your client. So several things you want to consider, tips. I think a lot of them have been touched even by Andreas. So the first thing that I think is the foundation is you must master your case. There's no way I can emphasize that. You must understand every little detail about your case, the facts. And I think for me, the facts is 99%. If you can go through the entire documents, all the pleadings and everything that you need to file in writing, and you know your case offhand, then you are more than one step close to at least being a good oral advocate when it comes to that. So you must understand your case, you know the laws, you know the facts, and you are prepared. Even your witnesses, you carry them along. And that then takes you to the second point, which is how do you then prepare for your oral hearing? And I think what you need to do there is you have to be focused. A lot of what Andres said about how you take everything that has been filed and written, your testimonials, your submissions, and compress it into perhaps 4 points or 5 issues. You don't want to have too many issues. That's obviously telling you that you haven't done a lot of work, or you still need to understand more of your facts or more of the evidences that you need to put. You want to really go into what is important. What exactly are we talking about? No matter how complex it is, your own work as a counsel is how to help or assist the tribunal in understanding exactly what the main issue is, if there is one issue, if it's possible to have one issue. Otherwise, we don't want to have like 10 issues or 5 issues, if you can reduce that. So no matter how complex it is, you want to focus on your case, kind of like bring it down to what number of issues you have to deal with, and then address those issues, focusing on your strong points, because that is what you need to win the case. You distill your issues, you narrow them down, and then you bring out your strong points. What is your winning point? What exactly is the soundbite? What is going to win this case for you? And how do you convince the tribunal? And the flip side also is you would not ignore your weak points, your weaknesses. You still have to concentrate on those ones and be ready and prepared to answer questions, because that's where the questions will come from, particularly from the opposing side or even the arbitrators. They know you know your strong points, but they will want to get at you using your weak points. So as much as possible, while you focus on your strong points, keep an eye on the weak points and be prepared to answer those questions, because it will come. And sometimes that's when the tribunal will grab his pen to really put down what you've said. So focus. The first thing, prepare. Second thing is focus. And then another point is, for me, teamwork. It's very essential. It's critical. You can't do everything. And if you're going to be the lead speaker or the first chair, whatever you call it, you need to focus on what you're saying to the tribunal. And there are a lot of other things going on, amongst your team members that different people should step in to take care of, so you're not distracted. You don't want to be looking on the side and looking at notes while maybe the opposing side, there's something going on at that end, or the tribunal's body, the menu, you're not able to get it, because everything is important. So to focus on that, you need a good teamwork. You need members of your team to step in, to assist, in their different role. Is it the second chair or perhaps the third chair? Whoever it is, they all have to, everybody, it's not just going to be one person doing the job. So you must delegate roles and focus on your part. Everybody focus on their part and take whatever they need to take. Again, this comes with practice. This comes with being part and also passion. For me, it's passion. You need to have that passion to want to get to the very heart of it. And again, you need to be clear. So we are talking, we're trying to convince someone, the members of the tribunal or a sole arbitrator, on something very complex, construction, oil and gas, typically very complex matters that even as counsel, you're learning, even when you come in there to hear what is going on in that industry. So how have you condensed the issues? How have you distilled the issues and understand it and confident enough to persuade the tribunal members? So that's the art. So you must be very clear. Language, I'm sure someone else will speak on language. It's very important. You want to speak in simple, easy to understand language, because in the international arbitration, you have people from diverse backgrounds. You will have to put that at the back of your mind. If you're talking to a tribunal that has someone from Africa, maybe French-speaking or English-speaking, that's a consideration. You could have someone also, from the civil part, where they practice civil law, different from common law. So you have at the back of your mind all those things that you must have prepared for when you're speaking. Because if you speak and they don't understand you, then you've lost the essence. There's no point. What are we here for? And because, just as Andrea said, oral advocacy is what wins the case for you, if you are able to. So some arbitrators don't have the time, or they want to listen to you first. Tell them what exactly is going on in respect of this, your complex matter. Then they have an understanding. And from there, you kind of give them a roadmap going through all your submissions and what you have on the table. So you have to be very clear. And also, just as Andreas mentioned, candor is important. You need to be confident and also courteous. You don't want to do anything that would distract you from the focus, which is oral advocacy, ensuring you're watching them, looking at the demeanor, and ensure that they get the understanding. I mean, a lot of times, as I'm speaking, some of you are nodding. So I'm thinking, yes, that means I'm communicating. So you must communicate with your tribunal. You have to watch them. And if it's not you, someone else has to watch them to ensure that you're passing the right message across. And I think maybe Liz will have some more to add, right?
It's on. Is that on? Yes. I agree with everything you said. I really liked your emphasis on teamwork. In fact, it's very easy for it to look when you're in a hearing room like it's the person standing up who's the most important person in the room on a team, but that person can't do it. None of us can do all of that in a complex case ourselves. And so having good communication with your team, as you say, clear allocation of roles, knowing who the person is who will know the answer to the point of detail that has momentarily escaped you, notwithstanding your extensive mastery of the record, is huge. And so it's a team sport, oral advocacy. It's not a solo act, and I think that's important to remember. I echo everything you said, Igonikon.
Sorry, I was just going to quickly add. So it's a lot easier if you're acting for the claimant most times, because you have the strong points. You're the one that has instituted the claim. But if you're also going to be counsel for a respondent, what works for me is candor, because a lot of times, especially if you have a weak case, it goes a lot to do with the way you present your case, as honest as possible, and also you concentrate on the weakness in your case. If you find answers to that, I think that takes you, to the same level dealing with the issues. In addition to everything everyone has said, you, as a junior counsel, you would have practice, and you want to get to that point where you're a lead speaker. Also remember, when you get to that point, the sole purpose of oral advocacy is to persuade the tribunal. So do not lose focus on the tribunal. Ensure that all through you are always watching and ensure that they are following in what you say. And take them along, because at the end of the day, they have the last word.
Maybe just if I may pick up on that, because we've been talking about advocacy as if it's just talking and talking and talking. Remember, advocacy goes beyond that. You need to listen. You need to be a good listener and a good observer. It's important that you detect, that you see, you know, how the tribunal is receiving your case, and the perception and the measure that the case is being presented and accepted. So listen, be a good listener and a good observer as well.